You've been served. It's that threatening delivery of documents at the beginning of a lawsuit. We see it in movies, TV shows, but what does it actually mean and what's your legal obligations when it happens? My name is Bobby Buchanan. I'm the host of Illinois Divorce TV and a practicing divorce attorney in the Chicagoland area. Today we're going to talk about service in a divorce and what it means for you and the most important steps that have to be taken and some common misconceptions about service. First and foremost, when you're served, they don't actually have to say anything. And also, you don't have to sign anything. Just the mere delivery of the documents is enough to complete the legal act. And yes, it is a legal act, and you can't try to avoid taking the documents either. As long as there's a good faith attempt at giving you the documents, you putting up your hands and saying, I'm not going to take those documents, or whatever the case may be, the process server might just leave them on the doorstep then, and that process server is going to go back and draft a piece of paper called an affidavit that says that they served you, and that's all it really takes. So what does that mean once you've been served? It means that you're under the jurisdiction of the court, and you need to act upon that service. You will receive, when you get served, you will receive a summons, and that summons is the legal document telling you what you need to do. And it will most likely, in a divorce at least, it'll say you need to file your appearance and answer in court within 30 days. An appearance is a legal document that says, basically, I'm representing myself in this case, or if you hire an attorney, the attorney will file the appearance and saying, I'm filing an appearance on behalf of my client. And then the answer is your formal response to their petition. A lawsuit's either started in most cases with what's called a complaint or a petition. In the case of a divorce, it's a petition for dissolution of marriage. And your response is going to be a paragraph by paragraph, either admission or denial of what they've put down. Sometimes in a petition for dissolution of marriage, they will say that there has been dissipation. Dissipation is a legal term for you spending money outside of the marriage, and there's repercussions for doing that if they can prove it. So you'll either have to admit or deny in that initial document that what happened with that money, or whether you simply deny that it happened. Most likely is what you will put in there. Other times they will say that they're entitled to attorney's fees or that they're entitled to maintenance, and you'll have to admit or deny whether or not that is the case. If you don't respond, if you don't file your appearance, if you don't file your answer, it can have very, very serious consequences to your case. The other side could end the divorce without your cooperation and get exactly what they're asking for the judge, and you'll have no say. Now, you can, in most cases, unwind that, but you have a very short period of time to do it, and it's never guaranteed. I would never rely on the fact that you can unwind that sometimes to allow yourself to drag your feet. Once you get served, that is the time where you either need to do the research to represent yourself and follow the mandate of the summons, or talk to an attorney. There are specific cases where you might not be filing an answer, and filing an answer could actually hurt your case. There might be a strategic reason not to file an answer and to actually file a special kind of motion. There are motions that you can file to say, hey, wait a minute, this case shouldn't be in this court. This is the improper venue or the improper state, or whatever the case may be. But there are motions that you file instead of filing an answer that could help you strategically. That's why when you're served, it's really, at a minimum, you should be conferring with an attorney and getting some advice on what needs to happen. I've represented a lot of people that just went ahead and filed their answer and actually handcuffed us as far as what we could do at the beginning of the case. We would have preferred to file a motion to get some leverage in the case, but we couldn't because they went ahead and said, oh, this is just paperwork, we just need to file this, and we're done. So that's about it. I think the main takeaways from this video I would recommend would be, one, you're served once that document is given to you. Nothing needs to be said. You don't need to sign it. The clock starts ticking on you having to take action once you are served, and you should make sure that you confer with an attorney so you're not taking the wrong action and you understand your rights and responsibilities as it pertains to you and your divorce. If you have any questions, comments, concerns, put them in the comment box below. I'm happy to see if I can help you, and I'll see you on the next episode. Have a great day.